All right, now try it. So our first technical issue has been presented, and we'll see if it has been overcome. Still no sound? It's on now. Okay. See how quick a technological issue can be overcome. So, all right, thank you. I was about to call the docket. First case, but the second case to be argued is Knight versus Rippey Oil.
Brian Cathy on behalf of Knight. We're ready to argue, Brian.
Let me find your name here. You said Brian?
Brian Cathy.
There it is. All right. Thank you, Brian.
David Gunn for Rippey, along with my colleague Joshua Smith. And we're ready.
And will both of you be presenting some part of the argument?
Yes, Your Honor.
No, we do not keep time.
Absolutely.
Joshua, you know what's going to happen. He's going to take whatever amount of time he wants, and whatever is left is what you're going to get. You understand that?
Yes, Your Honor.
I'm not gonna make him be quiet at the end. Okay.
It's a seniority system, Judge.
Okay. All right. And the next case on the docket is Native Oilfield Services versus Texas Chrome Transport.
Steve Aldis for the appellate, Native Oilfield Services, and I have no issue.
Good morning, Your Honor. Joe Rubio for Headwaters Resources. I'll be arguing for the appellees, and we're ready to proceed.
Joe Rubio the third,
Yes, Your Honor.
to be correct. All right. We do allow people to move around during oral argument, but be courteous to the folks that are arguing. Don't try to limit it so that we're not distracted. Also, check your cell phones and pagers. Make sure they're in the off or silent. You may hear one of my email bings during this because this is all done through my email system, and I apologize for that if that happens. To my left is Rex Davis. He is former Chief Justice, former Justice for years after he returned. He is now retired, and he is visiting judge on this panel. To my right is I guess I can still say our newest justice, Matt Johnson. He joined us in January upon the retirement of Rex in the run for the open seat. Matt has had one oral argument. Well, he was a briefing clerk here, so he's seen a lot of them, but we participated in one via Zoom. And then we had another oral argument, but he was recused on that panel, so he didn't get to sit on it. And so this is his first as a justice oral argument in the courtroom. So with that, that's Matt Johnson. And then next month, we're going to have another oral argument with our newest judge, which will be a fellow by the name of Steve Smith, who comes to us as a former trial judge from Brazos County. By the way, Matt was a 14-year veteran of the trial bench here in McLennan County. And so he comes to us with a lot of judicial experience. And so you've got lots of years of experience on this panel. So with that said, we're going to hear the Native case first. And Mr. Aldis, I think you are up first. The time is 20 minutes. You have 5 minutes of rebuttal. It does not come out of your first 20 minutes. If for any reason we get interrupted by technical difficulties or anything else, we will extend the time or adjust the time. And we may tell you to be quiet early. We probably won't. I've never done that. But we may give you more time depending on how it's going. And then you'll have 20 minutes and then 5 minute rebuttal. So it's 20, 20, and 5. Gentlemen, anything else?
No, sir. No, sir.
You've been through this a few times, so if I forget anything, you've never seen it. So if there's something you think I need to cover, let me know. You're so, all right. I needed that feedback. So, Counsel, you may proceed when
Thank
ready.
you. May it please the court. It is nice to be here live, but I will confess that there might be a bit of rust as a result of an extended layoff, not to my own doing. And it is good that the court will provide stoppage time just in case something happens with respect, just like in a good soccer match. Your Honor, we're here, and really there is one issue for this court, and that is whether or not the assignment of a claim against C&J by Native divested them of any right to sue the appellees in this case. And I submit to you that the only issue is whether or not the wording of that assignment justifies the way Native says it is or justifies the way the appellees say it is. The facts of the underlying case are really not heavily disputed from the standpoint of what happened. Native provided oil field services, logistics, delivering fracking sand to well sites that were owned by Juno, operated by, at least in part, by their contractor C&J, who contacted then Native and said, we need a load of 100 mesh, white sand from Uniman in Marshall. We then contacted our subcontractor, who is TCT, who contracted to MJR and its driver, Mr. Griffin, who went out to East Texas to pick up the material, but ended up, instead of going to Uniman Marshall, ended up at Headwaters, presented a purchase order for 60 loads of 170 white mesh sand. Headwaters looked at it, replaced it with another purchase order, and loaded the truck with fly ash instead. Fly ash is the byproduct of coal burning in some of the power plants, and it's used in making cement. In any event, the truck is a sealed truck, and so it proceeded back to the well site and then delivered a truckload of fly ash, which was loaded in with white mesh sand, which then contaminated the white mesh sand and was eventually put down the hole and allegedly caused damage down the hole. Before this suit was filed, C&J filed bankruptcy, and that claim is still pending, or that bankruptcy, I believe, is still pending in the Northern District of Texas. Native then sued TCT, Headwaters, MJR, Griffin for negligence in the picking up and delivering the wrong product. The defendants may move for summary judgment. I guess let me cover this. In the bankruptcy, Native sold its bankruptcy claim against C&J to an outfit called Cherokee Asset. Some of these companies go around, they buy up claims for a discounted amount and then assert the claims in bankruptcy with the hope that they'll achieve or recover more on the claim than what they paid the person who sold the claim. And I submit to you that that particular assignment is what really is before the court today. So after we sued them, they moved for summary judgment, alleging that Native was deprived of standing as a result of its assignment of its claims against C&J to Cherokee. The trial court agreed, wrote a letter to that effect, ruling only on the motion, the traditional motion for summary judgment that claimed lack of standing. There was a no evidence motion with respect to the fact of damage, whether or not Native had in fact been damaged at all. That was responded to, but the trial court did not reach that. So the actual assignment says that the seller, who was Native, assigned all rights, title, and interest into the claims and any reclamation claims as more fully defined below. The claim being the all rights, title, and interest to the reclamation and cure payments made on account of seller in bankruptcy, any proofs of claim, the right to vote any question in the claim in the bankruptcy case, and any amount listed on C&J schedules in the principal amount of $1,160,000 and change against C&J in the bankruptcy court or any other court with jurisdiction over the bankruptcy proceedings. I submit to you that the assignment assigned only Native's claims in the bankruptcy court against C&J. The appellees were never mentioned. The misdelivery of fly ash was never mentioned. Only natives' claims against C&J. So the appellee's position is that native assigned the basis of its damage claims against the appellees.
And so that we're all clear, the specific invoice, or since 100 grit sand wasn't delivered.
Purchase order.
Yeah, is that purchase order
so.
part of that assignment?
No, that purchase order is not referred to or mentioned in the assignment. There is no mention in the assignment of this dispute at all. Meaning whether it referred to it as, misdelivery of fly ash or whatever. And I believe the appellees make this argument because the way that the damages that natives suffered is going to be calculated is because Juneau made a demand of indemnity of $1.1 million on C&J as a result of the misdelivery. C&J then in turn refused to pay $1.1 million worth of invoices that were due to native.
Does the record reflect whether or not that offset fully resolved C&J's claim against native?
I believe it's one step removed. In other words,
If it's not in the record, we can't talk about it, but I needed to know if that was in the record.
I don't believe so,
Okay.
but this is what I believe is in the record. Native sold its claims against C&J to Cherokee, and therefore that cut off Native's claim against C&J, period. Now it's Cherokee's claim to run with, and I don't know if it's resolved.
Okay.
So the real question comes down to their appellee's characterization that we gave away the basis of our damage claim versus with the way that every other court has looked at this is decides it. Does the assignment, based upon normal contract construction, give away our claims against the appellees? The answer is no, not even mentioned. The second thing is what we gave away so broad that you can then say, well, that's so broad that it must include those claims. And that's not true. So every assignment is looked at just like any other contract. You do, if it's unambiguous, you go through all the steps. But they never did that. That is, the appellees never entered into that. They never argued that it was ambiguous. They never argued that it was anything other than, well, you gave up a claim against C&J, therefore you can't sue us. To me, that doesn't really make sense. There are two cases. One that I cited in the brief, it's called Vertical North America versus Vopak, and it's from the Houston Court of Appeals. In that case, Vertical North America had a claim against Vopak. Then Vertical North America's parent company, Vertical UK, sold the shares of Vertical North America to another entity. And when they sold those shares, the defendants argued that, well, by selling those shares, you necessarily sold your right to proceed against Vopak in this case. And the Court of Appeals said no. They said that there's nothing in the assignment that says that Vertical North America was giving its claims against Vopak to anybody else. And they went on to say that there were other issues in that case, that they retained indemnity and things like that they continued to pay for. But the real focus I have is that they talked about the claim. The claim. We did not assign any claim against these appellees to Cherokee, not even mentioned. And I think that the reason that I can stand up here and say this with some I guess, lawyer snobbery is that the appellees did not argue the language of the assignment one time in their brief. In their argument, they never mentioned the language of the assignment. And that is really what the court has to go on. It's not their characterization of it. It's not my characterization of it, but what does it effectively do? There's another case that was cited, that is not cited because it was well after the briefs were filed. And it was, which cited the vertical. And that case is a Houston Court of Appeals case called Comcast versus Houston Baseball Partners, 2021 Texas App Lexus 4800. And it was decided in June 17, 2021 in 14th District, and a petition has been filed. But this related to the Astros when the new people that bought the Astros claimed that the former owners of the Astros lied about the amount of value of the TV contracts that were going to have part of the Astros ownership. And the claim was that when the new entities that bought the Astros, as they sometimes do, there's an entity that negotiates the contract, and then they're going to transfer the rights to the contract to a new entity so that that entity becomes the holding company and so forth. Well, the defendants in that case argued that by virtue of that assignment of the rights to the PSA to this new entity, it deprived the Houston Baseball Partners of standing to assert a claim against the defendants. And the court said the PSA specifically contemplates assignment of other contracts, but there's no document in our record demonstrating that HBP has assigned its rights to the cause of action asserted here. So the focus should be on, did you assign a cause of action? Clearly, that's not the case here. The language of the assignment, to Cherokee only relates to C and J. And then the question then is, or is the assignment so broad that it must include all rights related to the lawsuit against the appellees? And the answer to that, no, because they never even mentioned the incident and so forth. There is no body of law. There is no case that they can cite that says you transferred to someone else the basis of your claim of damages. Without it being, I'm giving away, for instance, they cite to a case, I believe it's River Consulting, we both cite to it. But in that case, the party that was assigned their accounts receivable to someone else. That someone else then entered an appearance. But in the process of filing motions to substitute and so forth, the entity that did the assigning said, we not only assigned our accounts receivable, but we also assigned all causes of action related to it. And the Court of Appeals found that that was definitive to say that what they intended to transfer was not only the accounts receivable, but all rights to causes of action for the accounts receivable. And that's just simply not the case here. There is not a single, all of the cases that have been cited by the appellees, I believe, are general to the statutory language of, or I'm sorry, to the case law relating to standing on its own. But there is none that says that this assignment was so broad, or that looks anything like this assignment, such that it cuts off your rights against other parties. Think about it differently. If we'd sued C&J and settled with them for the $210,000 that we got when Native sold the claims to Cherokee, what would that be? That would be a settling party that would be dealt with either by Chapter 33 of the Civil Practices and Remedies Code or by other decisions as they won satisfaction. And the way that that works is the defendant comes forward and says, look, they accepted money for a potential part of this claim. The burden then falls back on Native to prove what part of that claim is related to their invoices that weren't paid and what part of the claim is related to the damage done downhole by the fly ash. That's the way it's supposed to work. And there's no difference if you look at it from the standpoint of whether we settled with C&J or whether we paid or sold it to Cherokee.
Does C&J, and again, I've got to limit you to the record, does it reflect whether or not C&J still has a claim against Native for damages? in the bankruptcy? Have they listed that as part of their assets, or do we know?
That's not part of the record.
Okay. Is there anything in the record that tells us whether or not Native's assignment to Cherokee will allow Cherokee to, in effect, settle the C&J claim against Native? In other words, I see the claims up here for the invoices,
Right.
and that are in effect otherwise unrelated to the fly ash incident. But we've got one entity over here, C&J, that's in bankruptcy, that both has claims being asserted against it and then has a claim that would seem to be independent of it, of those claims. And I'm trying to figure out whether or not there's anything about Cherokee's relationship as an assignee of those invoices or POs or receivables that would give them the right to negotiate with C&J. Anything about bankruptcy law or?
Well, let me just say this. The assignment itself says the Cherokee stands completely in our shoes with respect to dealing with C&J related to our bankruptcy claim. So I think you could take from that whatever the give and take is between Native and C&J in the bankruptcy has now been handed over to Cherokee, and they will deal with that. I will say that in the underlying case, in this case, Applebee's did designate C&J as responsible third parties. So as a responsible third party or as a settling party, C&J is going to be on that jury, on the jury charge.
What about Cherokee? Have they been designated?
No, Cherokee, of course, is just what I call, well, I probably shouldn't say this on YouTube, but a little bit of the bottom feeder at times. They come in to grab the claim, try to get a little more.
But they're not listed as a possible third party.
No, Your Honor.
Now, you said C&J was listed as a settling third party. They're in bankruptcy. Do we have to, is this,
There's no stay.
okay,
There is no claim against C&J. Even the responsible third party, as the court knows, that they don't have to show up and defend. It's going to be Native's job to defend
okay.
whatever actions that the Applebee's claim.
We had noted that as we were preparing, and we were wondering how the bankruptcy might affect our ability to go forward. So, okay.
I will say that I'm not a bankruptcy lawyer, but I play one in court kind of sometimes a little bit. And I know enough to say that I feel comfortable that there is no bankruptcy stay that would affect this court or the ability of this court to deal with our claims, that is Native's claims against the Applebee's, which do not include C&J at all.
Okay.
Was this in line with what the chief's line of questions are right now? I have been a little troubled with that too, because I know enough about bankruptcy to be dangerous to myself. And was this a Chapter 11, or first of all, I'm asking for record only. I'm not asking for outside.
I believe it is.
It is an 11, and I think in your opening statements, you said it's ongoing, perhaps. Is that right?
Well, I have to admit to Your Honor, I have not gone back to see whether or not this day was open. I do know at some point in the past, after this appeal was filed, that I had requests for information.
All right, let me ask it this way.
But
I
the
don't-
assignment refers to it as Chapter
Okay.
11.
I don't know what all you put at this point. We can go back and look, and we probably will, but I don't know what all you put in front of the 85th Court. Did the affidavits, did any other discovery of yours or the other side that you have to recall get off into the Chapter 11 proceeding at all?
No, there is a declaration. Of course, the assignment is part of the record. And there's a declaration from Native's former president, John Barclay, that's at 2 CR 215 to 217.
That was what, 2 CR?
215 to 217.
All right.
Where he discusses, and it has also some exhibits attached to it, where he discusses what happened and how that harmed the Native. But I have to point out that The appellant's argument or appellee's arguments in the trial court were not that we can't recover certain amounts of damages, is that Native hasn't been damaged at all. And unless you have any further questions, I see my line is blinking.
That's what I'm done.
Thank
We may get back to that damages because I suspect that we're fixing to hear something about that. So. Counsel, you may proceed. We're ready.
Thank you, Your Honor. May it please the court.
Can you go ahead and knock out what y'all put, your side put in front of the trial court as it pertains to bankruptcy at all, anything like that?
Thank you, Your Honor. I don't believe that we put anything in front of the trial court as
Right.
pertaining to the
In the
bankruptcy.
summary judgment proceedings. or-
Right, aside from the assignment, which as the court noted, does reference, it is a Chapter 11 proceeding.
Okay.
And I agree with my opposing counsel that that proceeding is still ongoing. It's not in the record, but I just looked it up. There's a notation in the docket that the claim that we're talking about.
Sure, we're good.
Again, Joe Rubin III on behalf of Headwaters Resources and the appellees. Your Honors, we would request that this court affirm the grant of the summary judgment because 8 months before this lawsuit ever began, Native assigned away the basis for its damages to Cherokee, a non-party, and it deprived itself of standing in the court below. And Your Honors, the facts are pretty straightforward, even though this is a little bit of a complicated business arrangement. There's simply no evidence of a loss or damage by Native to begin with. There is no evidence of an offset or withholding ever being effectuated by C&J against Native. There's no evidence of any monies having changed hands as between Native and C&J after the incident. And before any offset or withholding actually occurred, Native sold its claim against C&J to Cherokee before the lawsuit began. C&J did threaten to withhold monies from Native, but it was Native's burden to provide evidence that that withholding or offset actually occurred, and it just never did that. The record is absent on that particular point. In our brief, Your Honor, we talk about the responses to disclosures that Juno, or excuse me, that
Okay, let me make sure I understand where we're headed with
Sure.
with this argument. Because this was handled like a plea to the jurisdiction, but it was in a summary judgment wrapper, as I understand it. And normally pleadings alone are all you need for to survive a plea to the jurisdiction. And what you're saying is your summary judgment evidence, if it's traditional motion for summary judgment, which is what I understood we were here on, you've got to conclusively prove that they don't have standing. Whereas if it's a no evidence summary judgment, which the trial court did not get to, then the burden might be on them. But procedurally, am I understanding this correctly, that you are saying this was a summary judgment and we proved that they don't have a cause of action, or that they assigned their cause of action?
I believe that the summary judgment motion proved that Native lacked standing at all. So it's really two sides of the same coin, Your Honor. I understand the question. It is our position that Native didn't get damaged at all. But I think further, even if someone was damaged, that claim belongs to Cherokee as of December of 2016. And so there is no way that Native could have standing in the court below because it assigned the basis for its claim against the appellees before the lawsuit ever began.
What is your view of what the basis of its claim is?
According to its own petition at pages 11 and 8 of the clerk's record, it is the amounts withheld by Juno and C&J.
What if I come back and say that's damages, not the basis of a claim?
Well, Your Honor, I believe that the plaintiff, or sorry, the appellant in this particular instance needs to be held to account for what it pled. And what it pled was that it was harmed by the amounts withheld by C&J. There's no allegation or proof or evidence that Native's own people or its property was harmed by the alleged negligence of appellees. So what it's saying is, whatever appellees harm may have caused, we suffered that damage based on amounts withheld by C&J that well operated. And I think that's important, Your Honors, because the record is completely absent of any proof or evidence that any withholding or any deduction of invoices ever actually occurred. And so if If Native assigned the basis for that claim before the lawsuit began, it never had standing to bring the suit in the first case. The only party that may have been harmed, and we're not admitting that they have, would be Cherokee, and it's a non-party to this suit.
But the assignment did not give Cherokee, I mean, the language of the assignment, it's here in the record. It doesn't mention this lawsuit at all.
No,
It
Your Honor.
doesn't mention this claim at all.
It does not, Your Honor, and we don't dispute that. But if you take a look at the assignment, I believe it starts at page 174 of the clerk's record. It is for all right, title, and interest in and to the claim.
To the claim.
Right, and it also includes all agreements, instruments, invoices, purchase orders, proofs of delivery, and other documents evidencing or referred to in such claims. So the proof of claim.
Did your evidence prove that the specific transaction was even part of this assignment?
I believe our position, Your Honor, and I taking a look at the all-encompassing nature of the assignment is that because it wasn't carved out or accepted or reserved by Native, that the claim for damages based on amounts withheld was part and parcel of the claim sold to Cherokee. In other words, you had two sophisticated parties in bankruptcy. You had a claim by Native for all services rendered to C&J for approximately 1.16 million that was then sold to Cherokee. If Native wanted to reserve the right to go after the appellees based on amounts withheld or deducted, it should have and could have reserved that right, but it did not. And because it's not specifically mentioned or excluded as being retained by Native, then it was necessarily transferred to Cherokee upon the sale.
Did Cherokee indemnify Native in the event, in the assignment? Did they indemnify Native in the event that C&J in effect recovered on a claim more than 1.1 million, more than the invoices that it allegedly, I guess, offset?
I'm not sure if there was an indemnification in there, Your Honor. I don't know.
And is there anything in the record that tells us whether or not C&J has to look solely to Cherokee for satisfaction of its damages?
Not that I'm aware of, Your Honor. As far as the assignment is concerned, I believe Cherokee steps into the shoes of Native and can seek to recover upon that claim. And it's just our position that if anyone has the ability to seek redress from the appellees based on amounts withheld, that right now belongs to Cherokee as the owner of the claim for all services that were previously rendered by Native.
So how is Native protected from a claim by C&J for an amount in excess of what they assigned to Cherokee? Because as I understand the facts of the case, the 1.1 is what Juno suffered as damage to the well. And then C&J may have suffered additional or other damages, for example, changing out the sand in the hopper that was contaminated. So the damages may go up at the C&J level. And then Native may have incurred other damages, and I think has alleged reputational damages as part of their damages. So how does the assignment, because that's what we're kind of here on, is how does that cut off that ability of C&J to make additional claims, ergo Native's obligation to pay those claims if they're valid, and then their ability to turn and pivot and look to the, I guess you'd say, wrongdoer to make them whole? And I admittedly, all this is alleged because none of this is merits based yet. And so I'm trying to get to where all of this fits together, because I'm not seeing the distinction that your client's making on the assignment of the basis of this claim. I see the basis of the invoices, the receivables, but can you help me out on why is this assignment that doesn't mention the litigation against your clients at all? How does that get wrapped up into the assignment?
Sure, Your Honor. I think I'd like to touch on one point you mentioned. There were some special damages that you mentioned. Those need to be specifically pled and provided, evidence needs to be provided in support. They were not. Talking about the assignment.
Summary judgment, whose burden is it to prove damages?
We need to disprove damages, Your Honor.
Okay.
And with the understanding that what we were arguing about here is the standing issue, we never reached the no evidence motion for summary judgment. To go back to your question about the assignment, Your Honors, I guess number one, I've mentioned that because the right to seek damages from the appellees was not specifically carved out, and it could have been, then it was part and parcel of that assignment. Number two, Your Honors, there are a couple of cases that we cite to in our briefs. The River Consulting case is one, and I believe what happened there was the assignor was an engineering firm that sued for breach of contract based on amounts that were not paid for services rendered. It then assigned that claim to another party. The defendants brought counterclaims against the assignor and the assignee, and then those parties countersued. And the court dismissed not only the breach of contract claim by the assignor, the original engineering firm, but also their claims sounding in tort. I think because the basis for their connection to the defendants was that contract. And so our argument here is that the basis for the claim against the appellees and its basis for damages were the amounts withheld or allegedly withheld by C&J. That just didn't happen. There are a couple of other cases that we talked about, Your Honors. One is the Gonzalez versus Dallas County Appraisal District case, where a plaintiff complained of unfair property tax treatment and then sold the real property. And the court dismissed the plaintiff's claims there because the basis for those damages, the real property, now belonged to somebody else. That's the same thing that's happening here, Your Honors. The ability to seek damages from the appellees is necessarily dependent upon Native's claim for payment from C&J. And because that claim for payment from C&J was sold to another party, it belongs to somebody else. Cherokee is the only party that may have a claim against the appellees, but it's of course not a party to this lawsuit.
We don't have to, and it's early in the case, so to speak, but there's nothing about the contour area of the law that we have to be concerned about as far as other cases that you would cite or he would cite having any impact on this.
No, Your Honor, I don't think so. There's an issue in that River Consulting case about the, I guess, the nexus between contract and tort claims on a later decision. The court distinguished, I believe it was negligent inducement, perhaps, but the central holding of that case is still intact. And no, we're not arguing any a distinction as between the contract and the tort claims. What we're focused on solely here is holding the plaintiff to the pleadings that it submitted to the court, which say that their damages are based on amounts withheld, and the fact that there is no evidence in the record that that withholding ever occurred at all, and that the fact that those claims, the entire claim against C&J being sold to Cherokee, deprived the Native of standing before this lawsuit was ever filed.
Well, really then, they're riding in on their negligence claim, and you're having to defend on the negligence claim. I mean, y'all talked a lot about assignment. The court, the chief has outlined for you a number of things we're all concerned about. But frankly, when you get to the bottom, if it is a standing case, but in isolation, the merits really are just a negligence case.
That's right, Your Honor. That's the claim at issue in the trial court, is negligence alleged by Native against the appellees. There are no allegations, proof, or evidence in the record that the appellees' actions harmed any of Native's people or property. So the negligence claim is really a claim for...
Except that, isn't it shown in the record that they're out somewhere around $750,000?
I don't think there's any evidence in the record to support that C&J actually withheld monies or made a withholding or deducted any amounts of invoices.
But You agree that they assigned, that the record supports that they assigned $1.1 million, more or less,
Yes, Your Honor. We don't dispute that at all.
and that they got $250,000 for it, more or less.
I believe it was $210,000, but yes, Your Honor, they resolved that.
Okay, so on that evidence alone, they're out $750,000, $800,000.
As a business practice, they are.
Okay, now, if you're liable for, and obviously I'm talking about your clients in the lawsuit and the allegations, I'm not talking about merits based here yet. If they're liable for those damages that Native had to, in effect, give up, they made a business decision to sell that receivable for $200,000, and you get the benefit of that under Chapter 33 or responsible third party or something in the lawsuit. They may have made a business decision that saved your client $200,000. Whereas if they just let it ride in bankruptcy, for example, if Cherokee doesn't get a dime, then your client is still on the hook for the results of, or the damages caused by its negligence, which would be that Native can't collect its $1.1 million from C&J.
I understand the court's question, except that's not what the petition is alleging. It's not alleging that they lost out on the entire 1.16 million. What Native alleged was that it suffered damages based on the amounts withheld or deducted. So I don't think we would quite reach the 1.16 million. We don't know. We haven't proceeded that far. But I don't believe that that's what's alleged in the petition, and that's what we were trying to hold the plaintiff to, was that they had alleged it was amounts withheld, and then there was no evidence in the record to support that. And the fact that Native sold the claim to Cherokee meant that Cherokee could be the only party to prosecute that claim. The trial court caught on to this, Your Honors, during the motion for summary judgment hearing, noting that the claim against C&J is where all the damages are located. The Native sold the $1.1 million claim, and Native got paid $210,000 in exchange so that Native settled that $1.1 million claim. The trial court.
But you've already told me that we don't, the bankruptcy is ongoing. We don't know what the status of C&J's claim is.
That's not in the record.
Okay.
It is ongoing, but the trial court noted, Your Honors, that by trying to retain the benefit of selling its claim, in other words, $210,000, and then turning around and seeking damages from the appellees in the case below, Native was trying to double dip. Those were the court's words, Your Honors, double dip. We couldn't have stated it better ourselves. It's much like in an equitable subrogation claim or a claim for contribution or indemnity in the construction litigation context. A general contractor cannot seek to settle with the property owner, in this case being the well operator, and then turn around and try and obtain damages from a subcontractor, in this case being the appellees. That's a pay and chase scheme, which is prohibited by Texas courts when it's brought by a joint tortfeasor. That's exactly what what Native was trying to do here, was trying to retain the benefit of that $210,000 and then try and obtain a windfall recovery against the appellees.
Well, it's out $1.1 million. How do you get to the windfall?
It's possible if we go through the trial proceedings and Native were to obtain $900,000 or $1 million, that it could end up obtaining more than $1.1 million. But the fact is that it settled that entire claim when it sold it to Cherokee. All the rights pertinent to that claim, including the ability of whether an offset was proper or the amount of that offset, now belong to Cherokee. And they belonged to Cherokee since December of 2016, 8 months before the lawsuit began.
But in your defense to that the business decision was bad and they failed to properly mitigate their damages.
That's certainly something we would bring up in the trial court. Our argument in the court below was that any argument about whether amounts were withheld and how much those should be belong to a different party. And Cherokee is just not a party to this lawsuit. Native deprived itself of a justiciable interest in the controversy when it sold its entire claim Everything that's mentioned in the assignment on page 174 of the record, everything that's mentioned in the proof of claim at page 118 of the record was sold to Cherokee, including the right to seek damages from appellees based on the amounts withheld. And it was at that point, 8 months before the lawsuit ever began, that Native deprived itself of standing. Standing is a requirement of subject matter jurisdiction. The trial court held that it didn't have standing. And for all those reasons, Your Honors, we would ask that you affirm the grant of the summary judgment.
Thank you, counsel.
Thank you, Your Honor.
Now, counsel, in the next argument, I want y'all to notice the yellow light came on and he finished before the red light came on. Just an observation here.
I'm getting in position so that I can.
You may proceed.
Your Honor, you nailed it right on the head. This traditional motion for summary judgment, in order for the defendant, the appellees here to prevail, they must disprove the existence of personal harm to Native as a result of this. The assignment itself does not prove that. There is no evidence submitted as to whether or not the particular invoices that were attached to the misdelivery of the fly ash was part of that assignment or not. But more importantly, it's like the Houston Court of Appeals said, Vertical North America has standing to assert the claims against VOPAC unless the record shows that it is completely divested of any justiciable interest. That's at page 6. And what we have here is we do not have evidence that the assignment alone took away our Native's justiciable interest in the controversy. There's a difference between the controversy and the claims. You could assign, Native could have assigned to Cherokee all of the matters incident or related to the misdelivery of fly ash by any person thing, including all claims associated therewith, but it didn't. It assigned a bankruptcy claim that had been filed based upon the non-payment of invoices. And I think, Justice Gray, you hit right on it when you said that, well, you say it's a windfall, but if it's a windfall, that's because the lawyers don't do their job to either ask for a credit or to submit them as a settling or other party. There's also there's a little bit of a disconnect. I know that the trial court ruled solely on the traditional motion for summary judgment. However, Native did produce evidence actually that they were docked $1.1 billion. Barclay testified.
You're not going to make us chase all that, are you, on a no evidence motion for summary judgment that we didn't get to, or that the trial court didn't get to?
I'll tell you what, Your Honor, you and I can have an agreement. If you don't reach it, I won't reach it. But in any event, the testimony.
I mean, literally now, I'm a little bit serious about that because we really don't have to get to the no evidence summary judgment motion, do we?
No.
Okay.
So the question though really did come down to whether or not.
I'm gonna stop you, counsel, and do something I have rarely done. Do you agree that we don't get to the no evidence motion for summary judgment?
Yes, Your Honor, the trial court did.
Okay, thank you. Appreciate that. Sorry for the interruption.
No problem, Your Honor. Just so that we're clear that in the trial court, it was the burden of the appellees to show that Native did not suffer a particularized injury, which is the first of three steps for standing. One is you suffered a particularized injury. 2, it's fairly traceable to the actions of the defendants. And 3, a court could likely redress that with a money judgment or otherwise. I submit to you that defendants did not prove that Native did not have standing. The court should remand this case to the trial court. Thank you.
Do you have the full site of Vertical in front of you?
I do, Your Honor. It is.
And Comcast as well, please.
Sure. Well, I said that Vertical is 2017 Tex App Lexus. And the only reason I had to refer to my notes is because I inadvertently cut off it is 2017 Tex App Lexus 8944, September 21st, 2017 petition denied.
Okay.
And the Houston Baseball Partners case is Comcast versus Houston Baseball Partners, 2021, Tex App Lexus 4800, Houston 14th, June 17th, 2021, petition filed.
Although we have repealed our local rules, we do have a kind of a precedent in this court that if you cite to a case that was not in your brief, that you file a letter supplementing your brief with those citations by Friday. If that's not workable, just let me know now and we'll, make it later. But basically, if by Friday you could supplement with any cases that you that were not in your brief, that would be very helpful to the.
Thank you, Your Honor. We will.
Thank you,
Appreciate
counsel.
it.
This case is submitted and y'all are excused. Court's going to take about a 5-minute recess. Thank you. All right, at this time, the court calls Knight Oil Tools versus Rippey Oil Company. Argument by Brian Cathy on behalf of Knight Oil Tools. Counsel, you may proceed when ready.
Thank you, Your Honor. May it please the court. The trial court's judgment in this case contravenes a number of principles of Texas law, and it cannot stand. Although the court has numerous paths to reversal, I'd like to focus on two that are fatal to Rippey's lawsuit here today. The first one is the absence of evidence of causation, and the second one is Knight's release and indemnity defenses, which the trial court wrongly took from the jury's hands on summary judgment. The absence of causation evidence requires rendition in Knight's favor. And if the trial court enforces the terms and conditions of the party's contract on remand, Knight would be entitled to judgment in its favor. If there's time, I also intend to explain why the damages are unsupported. Turning to the causation issues. The causation issues in this case implicate some engineering principles that are a little bit difficult to digest from reading the cold appellate record, because the experts were pointing to demonstratives that aren't in the record. And so you get a lot of, please turn to the slide and explain what this is. And we don't have those slides before us, but hopefully I will be able to articulate those principles to you all shortly. But before I do that, I think there's a couple of points that are really essential to keep in mind. The first one is that causation is important, but extremely difficult to prove in this case. This is not an ordinary negligence case. Rippey asserted a negligence claim and a whole plethora of other claims, but he waived all of them by refusing to submit them to the jury. The only two claims that were submitted to the jury were a breach of the implied warranty of fitness for a particular purpose and negligent misrepresentation. Both of those claims have a causation element, but this isn't a typical UCC case. Rippey is not claiming the difference in value between the pipe as represented and the pipe as delivered, nor is it a traditional negligent misrepresentation claim. Rippey's not claiming he was induced to drill this well based off of some representation by Knight. Instead, in breach of the terms and conditions of the party's contract, they're requesting millions of dollars in consequential damages for a loss that is very attenuated from the misrepresentations and warranties alleged in this case. Specifically, that they completely lost a well and could not reproduce that well anywhere on their 14,000 acres of leases, all simply because the outside diameter of a tool joint was a few tenths of an inch smaller than API premium specifications. Point number two, tubular failures were a common occurrence on this well, even for parts that complied with all recommended specifications. The 3.5-inch drill pipe at issue in this case wasn't the first or the last tubular failure on this well. There were at least 4 others. Rippey broke a 5.5-inch steel liner. That's steel 2 inches thicker than the drill pipe at issue. Rippey broke a steel motor connection by overloading it. Rippey broke 7 5/8-inch steel liner. So that's 4 inches larger than the drill pipe at issue. And he had a second motor connection also break. Is that a coincidence? Certainly not. The well conditions here were extreme.
But you're telling me all that was in the evidence
That is in the evidence. Yes, sir.
and that the jury heard all that and decided that that didn't affect causation in this case.
Well, I think the jury was influenced by a number of other things. And so to get to the crux of kind of the engineering principles, I don't think that, I think the jury was swayed by the limited expert opinions in this case that had absolutely no support. There was no, the evidence that was offered was completely conclusory, as I'll get to in a second. But I think that was the primary impetus. I don't think the jury was ever really grasped the actual issues, and they just latched on to the simplest story that was possible. And that is replicated by Rippey in their briefs. They ignore all of the specific engineering principles that apply to steel. This is a very well-developed area. And what do? They just draw an analogy to a used tire. And that's the whole crux of this is they're relying on analogical arguments that have no actual support in anything. And so I do think the jury was influenced by just the simplest story, which is implausible for a number of reasons I intend to discuss, Your Honor.
But is the implausibility from an engineering aspect, if you will, in the record that the jury could consider?
It was, Your Honor. And so I think we have to
And
draw.
didn't they reject?
I don't, well, clearly they decided for Rippey, but I don't know that they ever attempted to apprehend it. I think they just went with the simplest story that was put before them. And that was not one that was supported by the evidence. When you look at how the case really developed, there's virtually no expert testimony on metallurgy introduced by Rippey in this case. They didn't present any expert on those issues live at trial. Instead, they relied on depositions taken by my client and my trial counsel. And obviously, there wasn't a lot favorable to them in those cross-examined depositions. And so there was only a few pages of testimony that was introduced. The first expert is Mr. Ted Bruno, who wasn't a registered engineer. He had no advanced degrees and had never worked in the oil field. They offered 5 pages of deposition testimony from him. The second one was Hilton Pergine, who didn't have a college degree and was designated to test on drill pipe inspections and not on metallurgical failures. And his testimony runs for a total of 9 pages. So the entire crux of the causation case rests on 14 pages of deposition testimony under cross-examination. And so as this court's aware, conclusory opinions, even offered by the most qualified experts in the world, which I would argue these don't fit that category, but be that as it may, is not legally sufficient evidence. I mean, the Supreme Court in its precedent has been pretty clear that in order for testimony of an expert to be considered legally sufficient evidence, the expert must explain how and why the negligence caused the injury and establish a demonstrable and reasoned basis for which to evaluate their opinion. This requires an expert on causation to rule out other possible causes. Here, Bruno and Pergine's testimony is the very definition of conclusory testimony. And I think the jury may have been swayed by its superficial analysis, but under settled law, that is not legally sufficient evidence on which to support the jury's verdict. For example, Bruno and Pergine never explained how the alleged misrepresentation of the pipe's outside diameter played any role in the failure of the pipe body. Further, they didn't rule out other potential.
I thought there was testimony, and this is just from reading the briefs because I hadn't read the full record yet, but my understanding from reading the briefs was that the wear on the tool joints, both the pin and the box, if it was below the a certain standard, it indicates the amount of wear, and that if that part of the joint has worn, that means that the tube has been subjected to stress for that same amount, although it may not wear down in the sense it's still stressed.
That is certainly the argument that has been advanced by Rippey, but that is not supported by the evidence in the case. It's an apples and oranges comparison that's being drawn here. 2 points that would really, I think, need to be brought home is one, wear is not the equivalent of fatigue. Everybody agrees that this was a metallurgy fatigue failure. That's a specific term, and it doesn't correlate with wear. And in this case, there was no attempt. If you look at the 14 pages of deposition testimony that was introduced, there's no attempt to quantify the actual wear on the tool joints. You're not going to see anything from the plaintiff's experts, or excuse me, the police experts discussing how worn down these were. They just start with the premise that at one point they were larger than API premium specifications, with ignoring the potentiality and the actuality that these things were much smaller than the typical tool joint by design. And so they just assumed that it reached its post-accident diameter from wear down, but that's nowhere established in the plaintiff's expert testimony. And so when you really look at the API premium specifications, this drill pipe complied with them in every respect except the outside diameter of the tool joint, as you alluded to, Chief Justice Gray. But the outside diameter has absolutely no relationship to this drill pipe's failure. The failure occurred in the body of the pipe, not on the tool joints. And Rippey has not pointed out to any evidence or any studies that correlate fatigue failure, a technical term, in the body of a pipe with the outside diameter of the tool joint. A fatigue failure is due to a micro discontinuity in the metal. And so essentially it's a elemental or molecular imbalance. And through a repeated stress cycle, it propagates and it fails. There's no connection between the micro discontinuity in the body of the pipe and the tool joint.
Okay, because you're quickly running out of time, I need you to connect me between this testimony, preservation, and what you contend the result is.
Sure. So
How did you preserve your no evidence of, I guess it would be the breach of the duty and for a rendition?
correct. So through a J&OB motion, and I believe we also raised it in our motion for new trial. Obviously, the distinction would be in our J&OB motion, we sought rendition in our in our favor. And then in the motion for new trial, we raised the same absence of evidence, but requested a new trial for that.
And that would be no evidence of
Causation, Your Honor.
causation.
And so when you look at kind of, because I really think this is the crux of the case, and so I would like to spend a few minutes on it, even though I do recognize my time is lapsing, is Scott Harding, a metallurgist failure expert that the jury heard from with a PhD from Baylor. He explained that when you look at the engineering principles, if you actually had a thicker tool joint, it would have made it more likely that the pipe was going to fail in the body. And so it's the exact opposite of the relationship that's being offered by Rippey on appeal, is you brace the two ends with additional steel. And of course, where is any tension is going to push? It's going to push in the body of the pipe. And so the whole relationship is exactly backwards from the one that's being pushed on appeal. And when you look at the API guidance that Rippey relies on, it says nothing about a correlation between wear on a tool joint and failures in the body of the pipe. And specifically, they cite section 2.4.3.3 of the recommended practice for inspection and classification of used drill stem elements. This was exhibit 1 at trial. They screenshot this multiple times in their brief, and they attach it as exhibit A to their brief. So this is a key exhibit to them. But let's look at what it states. It states the bevel diameter is an outside indicator, outside wear indicator. The bevel diameter on the tool joint provides an indication of tool joint outside diameter wear. Tool joint outside diameter wear. There's no connection in that statement anywhere to body fatigue failures.
But didn't you just tell me a while ago that there was no evidence in the record that the failure in the tube in this one was because of wear in the joint, but yet, if I understood what you just said, there was no bevel on the joint that failed, and therefore that is indication that the tool joint in this failure, where it failed, that tool joint was worn by the extent of the bevel.
Well, I guess I'm extending further to the argument. I think the primary argument was that the tool joint as originally designed was smaller than an ordinary tool joint. So that explains why the measurements are small. But even accepting the fact that the tool joint was worn down over time, as they allege, that still is no evidence that would cause you to think that that was connected in any way to the failure in the body of the pipe. And so with the few final minutes, I would like to transition a little bit and discuss the trial court summary judgment.
Before you go there, I want opened up because the chief fuzzes at me for asking my questions after your time is up. He's very polite about it, but it has happened a number of times. I want somebody to talk to me about why both of you will talk about the damages, including call it its possibility of reversible error. I mean, are you serious about your issue on page 68 of your brief? And if you are, then save a little time for that. I frankly, in my view, it's not a throwaway situation of a 1.1 million recovery versus a 5.9 million. I kind of see that as a 4 million plus difference. So will you save a little bit of room to talk to us about damages, please?
I will, Your Honor.
Thank
And so I'll be brief on the summary judgment. The
Well,
trial,
I'm gonna need, as you know, you've seen our prior opinion, because this is really a very rare case where we've issued an opinion and gotten briefs on rehearing and set aside the opinion. So you kind of know where some of the lay of the land is. So
correct, Your Honor.
You got to go develop this for all of us where he just went. I don't disagree with that. We're all struggling, okay?
Yes, Your Honor.
I just don't want the damages to be treated as a throwaway, unless you want it thrown away.
No, I do not want it thrown away, Your Honor. And I will briefly discuss the summary judgment, because I do think that that was the primary focus of the motion for rehearing. I think that's an exceptionally weak part of the court's opinion and the trial court's judgment in this case. It really creates a harmful precedent that a company man lacks authority to contract for the acquisition of oil field equipment. With respect to the oil field specifically, the decision undermines the long-established expectations of the role of the company man and the procedures for doing business on a well site. Most of the contracts that are executed by oil operators are through their company men. And although Rippey tries to deny authority, their company man was the one with ultimate authority over this well site. And then sort of a more general view, the trial court's holding and the statements in this court's original opinion allow a party to just completely avoid unfavorable terms while binding parties to the favorable terms of their agreement, all by asserting after the fact limitations that he lacked authority. They rely on a single case for that, and that's Ford versus Garza. But that case doesn't support the holding asserted, and it certainly doesn't have the far-reaching implications that are being asserted in this case. The summary judgment evidence in this case conclusively established that Rippey's company men were expressly authorized to provide goods and services for the well, and not just this well, for numerous other wells. And that authority necessarily included the ability to contract to acquire those goods. It's meaningless to give somebody authority to do something if they can't necessarily carry it out. And so, like many other service providers, my company included terms and conditions, including releases and indemnification language in their work orders. That's standard in the oil field. And that the service contract in this case contained those provisions should not have been a surprise to anyone, including Rippey, who had a long experience in the oil field industry. And with respect to Rippey specifically, he had not only seen invoices and work tickets on this well, he previously paid them on other wells with the exact same terms. So there's no surprise. If Rippey, didn't bother to read the terms, that's frankly on Rippey. And so is the fact that he never told his company man not to sign these work tickets or not to enter into these type of agreements. All of that falls on Rippey, not on my client. The trial court, and respectfully, this court in its original opinion, seriously erred in failing to appreciate that a company man's express actual authority to acquire goods concomitantly entails the ability to actually contract for those goods. And that's the holding of the Fifth Circuit in Houston Exploration. And I'll skip down.
So if it goes back, go a little further with that. If it goes back, is what you're arguing about who had authority and who didn't, isn't that also colored by the fact that we're talking about the oil patch and that there's some factual distinctions that often occur because of the oil patch as opposed to a boardroom? In other words, when you get into these folks and what their authority was, doesn't the fact that we're in the oil patch, the oil and gas industry, sometimes color the fact that Mr. Rippey said, I don't read that stuff. I've got my folks. Well, you're right. It's on Mr. Rippey, but we got to look at it all the way around it. I mean, Mr. Rippey, maybe he's just doing what folks do in the business. Now, does that mean it reverses and looks at it? It very well might, depending on what the court does. You see what I'm asking?
I do, Your Honor. And so I think this is really the distinction you're drawing is between two opinions. One is the Houston exploration opinion where they rendered judgment on this exact issue, and then the Ex-Pros Americas case where they said there's a fact question. And so I think the position taken by the Fifth Circuit in Houston exploration was, well, as a matter of law, we don't care what the practice is in the oil patch. And I think in America Ex-Pros, there may be some factual distinctions in the summary judgment evidence, but they said, really, all of that surrounding context, that should be submitted to a jury. But we were deprived of that opportunity. So that may well be a plausible jury argument. And they can present, whatever experts, if they get to that stage of the proceedings, to the jury and evaluate it. But we were deprived of all of that evidence. And so I think it's just speculation as to, in this case, since we were deprived of that opportunity. And to turn to the damages, in this case, the reason I didn't start with it is Rippey's not entitled to any damages.
Yeah, but you pretty well make, I'm looking at page 68 forward. And I'm not being critical. I just think you're being tactically sound what you got to do. You pretty well edge into the fact that, well, yeah, but because the issues 5, 6, and 7, it may be that if nothing else, they get 1.1 million because that's with the 300,000, and your prayer for relief is conditional. And so again, a lawyer's got to take care of his business, both at trial and appellate. But isn't that where we are? That essentially our base in looking at the damages here, and we don't have a lot of time, so I know, and I'm troubled about the standards. I'm talking to, Mr. Rippey's probably the president, CEO of the company. There's some pretty serious law that says that doesn't make him the owner. The
Yes.
owners are the shareholders. And so you can get off into evidence questions pretty quick. My point is, am I reading your brief wrong or not?
No, you're absolutely correct. We make the conditional request is if you can't render judgment, which I think you should, or you can't remand a trial, which I think is the absolute minimum, certainly the damages need to be reduced. And I
So
would ask that you render judgment.
we need to study your case with the briefing you've done.
Correct, Your
Including
Honor.
the conditional award, if you will. I'm not,
If you get there, Your Honor, yes.
if we get there. Okay, that's mainly what I wanted.
And I mean, I think really the primary request on the damages is to reduce it to the $1.5 million replacement cost that was
Less
estimated.
300,000.
Less, yes, Your Honor, less the 300,000. The jury found that the cost to drill and equip the Easterling 2H well was less than the decrease in the 1H's value, and that should be the proper measure of damages. I think there's sort of an issue related to the charge here. You have to measure the evidence on whether the well was reproducible under the correct charge. We objected to the charge. The charge that was given was unduly restrictive in its scope. It basically instructed the jury, could you have reproduced the well in the exact condition at the exact spot as it existed before the time of the occurrence?
Did you
Obviously.
object? Did you object on measure?
We did, Your Honor, and that was the precise arguments that were advanced in the trial court, was that it was unduly
So
restrictive.
there's no question you have preservation.
They have not raised it. I do not think there's an issue there, Your Honor. And so here the competent evidence demonstrates that the well was capable of being reproduced. As you alluded to, Mr. Rippey basically says, I'm the owner of the properties, which he was not. This is a corporation or a legal entity that's at issue. But being that as it may, his testimony on this issue was scattered at best and was not competent in any way. Their own marketing materials demonstrated that the drainage pattern for these shale wells were 149 acres. The one